Right off the bat, a no-show. In court, that's never a good look. When a defendant misses a hearing, the judge can forfeit their bond, basically yanking back the money or collateral that guaranteed they'd appear. But notice Judge West's balance here. Firm on the forfeiture, yet still fair, offering to recall it if he arrives late. Classic example.
Good.
No response, Your Honor.
All right, his bond will be forfeited for non-appearance and reset at $100,000. He did call, say he was having issues. If he gets here late, then I'll obviously recall that bond forfeiture.
And Judge, like I
You've
said,
got Karis and, oh, go ahead, I'm sorry.
he did call this morning. When I tried to call him back to his house number, he was already gone, so I'm assuming he is trying to.
Maybe on his way. Okay, thank you. And then you've got Karis Antoine, Mr. Lewis.
Yes, ma'am, Judge.
Are we? Okay. You're Karis Antoine? And this is cause number 24 DCCR 1878. It looked like I did sign an order back in May for CPS records.
You did, Judge.
Of judicial discretion at work. Here's where courtroom patience meets bureaucracy. CPS records can make or break family-related cases, but getting them? That's another story. Judges sometimes have to personally nudge government agencies just to get a file. You can almost feel the courtroom's collective sigh. Everyone waiting on that one missing piece of paper.
We contacted them this past week asking for an update. They hadn't gotten back with us yet.
Okay.
I even had Mr. Hoffpower call because he's used to dealing with them.
Right.
And he did that for me at the end of the week, and they hadn't replied yet.
All right, we'll reset that just another 30 days. If you'll make a sticky note for us, we'll try to contact them as well and see if we can. Sometimes that helps to get things moved
So
along.
reiterate what said, I spoke to them by email, Stephanie.
Okay.
Adams, but we still haven't received those records.
And she didn't give any update on when we could expect them?
But it was Friday.
Okay.
I got contact.
She's usually pretty responsive.
Yes.
All right, so Mr. Antoine, stay in touch with Mr. Lewis. He'll let you know once he gets that information so you can go in and go over it with him. And then we'll try to get an announcement, hopefully if we get that before the next court date.
Thank you, Your Honor.
Thank you.
And off the record, I'll show you their email reply to Mr. Hoffpower's voicemail. Sound about right? 2 minutes, what, please?
He's giving you a hard time without saying anything.
I know, I understand. It's okay.
You can handle it.
Next game, I'm good.
Mr. Rojas, you've got Carnell Beard. Good morning, Mr. Rojas.
Good morning, Your Honor.
Good morning, sir. You Carnell Beard?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He would, Your Honor.
Are we going on?
This is where the stakes rise. When the judge says the charge is enhanced to a second-degree felony, that's not just legal jargon. It means the punishment doubles in severity. Prior convictions act like multipliers in Texas law, boosting the range from a few years to potentially decades. It's the system's way of saying, we remember your past.
Count one. Oh, no.
No, ma'am.
Okay.
Everything.
Okay, let me, all right, and he'll waive the formal reading of the indictment.
He will, Your Honor.
Mr. Beard, you're charged with the third-degree felony offense of collision involving serious bodily injury from September 28th of 2024. Your indictment also alleges that you were previously convicted of attempted murder, second-degree felony, August 30th of 1999. And after that was final, you were convicted of possession of a controlled substance, a first-degree felony. Well,
Judge, I'm
do we
looking
just
at
need
the
to go on one? Or
Let's
is
just
that,
go on one, because I'm looking at the dates, and they do overlap, so it would not make them
it
habitual.
wouldn't,
It'll
so it
be
makes it a second-degree felony.
Your Honor.
So what that means, sir, is that the punishment range in your case would be enhanced to that of a second-degree felony, which is between 2 to 20. Do you understand?
Yes, ma'am.
And how do you plead to that charge?
Yes.
And is that prior offense true?
Yes, ma'am.
Okay. Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've read.
That was surprisingly lenient. a 10-year deferred probation, despite an attempted murder conviction on record. But here's the nuance. Deferred adjudication isn't a free pass. It's a conditional second chance. Violated, and the court can enter the original conviction and impose the full sentence. High risk.
It's just for a 10-year deferred adjudicated probation. There would be a $1,000 fine, and there would be restitution ordered as determined between now and when we come back for a pre-sentence, through a pre-sentence report. Is that your understanding?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Beard is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case. We'll also get that restitution amount determined, and then we'll come back later for sentencing. When you're on your way out of the courtroom today, you need to stop and talk to probation, and she's at that desk right there. All right, we'll see you back at sentencing.
Thank you, Your Honor.
And then you've got Zachary Turner, Mr. Rojas. Good morning, sir. Are you Zachary Turner?
Yes, ma'am.
And this is 24 DCCR 2197. And Mr. Turner, you're charged by indictment in this case with the first-degree felony offense of fraudulent use or possession of identifying information from April 22nd of 2024. Your indictment alleges that you were previously convicted of unlawful possession of a firearm by a felon, a third-degree felony, September 29th of 2014, which means that this...
High reward. Did you catch that? He just turned down a 15-year plea deal. With the habitual offender notice, that choice could mean life behind bars. It's one of those pivotal courtroom moments, a defendant betting everything on trial, knowing the odds are stacked sky high. Would you take that risk or take the deal?
Punishment purposes would be
15
enhanced,
15
but...
and 99 is the way we indicted, Judge.
Right.
Given the rejection of the state's offer today, I believe we can make him a habitual, and I will be filing a habitual offender notice in this case.
So, and you've gone over that with Mr. Rojas, correct? And so I want to make sure you understand that if the state files that notice of enhancement with another prior offense, which I would assume you have since the one I see is an unlawful possession of a firearm by a felon, that means that if you go to trial and you're found guilty, the minimum punishment would be 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And I have a plea bargain rejection here that has your signature on it with Mr. Rojas's that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 15-year term in the institutional division of the Texas Department of Corrections. And I would assume that would be going on count 1 only.
That's right.
And so you have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Turner, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? So, Mr. Rojas, you're released. Mr. Turner, if you'll just have a seat here in the courtroom, I will appoint someone. The clerks will call you up in just a minute with that information on who your lawyer is going to be. I also want to make sure you understand that after today, I will not accept this plea agreement. Once your case gets put on the trial docket, it either goes to trial, or if you change your mind, you can plea open to the court or to some different plea agreement, unless there is new information that your attorney or the district attorney's office receives. Do you understand?
Yes, ma'am.
Okay. If you'll just have a seat, she'll call you up in just a minute. Mr. West, you have Michelle Johnston. Good morning. Michelle Johnston.